This is the story of the Supreme Court case of Baker versus Carr. Some have given it the title of Redistricting Gone Sour for 60 years. This project was created by Daniel and yours truly, Tristan, also your narrator, and of course, the one and only Eric Nava. It all began when a man named Charles Baker, along with fellow denizens from Tennessee, alleged that a law designed to apportion the seats for the Senate's General Assembly was virtually ignored for over 60 years. Despite proportional increases in economic growth and population shifts to more industrialized sections, reapportionment had been disabled since 1901, thus violating the 14th Amendment's Equal Protection Clause. However, the question is, did the Supreme Court have jurisdiction over questions or legislative apportionment? And what is the test for resolving whether a case presents a political question? The answer is yes. Federal courts do have jurisdiction to hear a constitutional challenge to a legislative apportionment. But simultaneously, no, the case did not present a political question. Judicial standards under the Equal Protection Clause were well developed and had been open to courts since the enactment of the 14th Amendment to determine if an act is arbitrary or reflects no policy. Whew! So, from April 19th, 1961, all the way to March 1962, the Supreme Court heard the case. That is a whopping 23 months! But, finally, the U.S. Supreme Court, led by Chief Justice Earl Warren, forced Tennessee legislature to reapportion based on population. And so, in turn, every state legislature was reapportioned, causing political power to actually shift from rural areas to urban areas.